and John Mui Kinywa, Curtis Jeru Mawera, and Jeru Leo Wamuthende. So if we are agreed, I will just go straight to the analysis and determination. I can tell you what I did. I looked at the submissions of the parties at the end, and I realized that everybody veered away from what was originally indicated or drawn in the petition. The petitioners drew issues, a list of issues for determination. And the parties in their submissions did not necessarily follow those views or that list. IEBC only wanted to know whether the will of the people was achieved. The petitioner, the fourth respondent, wanted to know whether there was any move away from the rule on regularity. So there were those two sorts of issues. And I decided, because the petition had been already broadcast as a petition with a host of issues, I reverted to the issues that the petitioners had drafted. The petitioners themselves, what you did is that you compounded all your issues into just basically two issues, almost entirely on quality. And I decided, let me go back and deal with each of the issues that were not spent. The first two issues, if you remember, were spent through the first, the question of identity of the petitioner. So that does not feature at all. So these are the issues that I will be dealing with. One, whether there was irregular, opaque, and unlawful appointment and dismissal of presiding officers in violation of the Constitution and the general elections regulations. Two, whether alleged failure to deploy the printed register of voters and resulted in unlawful. Doesn't matter how many times you correct these things, you always find gremlins. Resulted in unlawful disenfranchisement of duly registered voters. Three, whether there was unlawful third-party interference with voter registration data and failure by the first respondent to secure and protect the register of voters. Four, whether there was violence, intimidation, and disruption of voting in violation of the Constitution, the Electoral Code of Conduct, and electoral law. Five, whether there was bribery, treating, and undue influence in violation of the Election Offences Act and the Constitution. Six, whether there was broken chain of custody and lawful handling of election materials and violation of procedure on close of polling. And seven, whether there was use of state resources, state security, and public office to influence voters, which constituted abuse of office and improper influence in violation of Articles 10, 73, 75, and 81 of the Constitution under the Elections Act. Those that I have read out were the issues that, according to me, raise questions of a qualitative nature. There was one issue, which is whether there was delay in counting votes, exclusion of agents, defective and falsified statutory forms, opaque counting and tallying in violation of Article 86 of the Constitution and Regulation 79 of the Elections General Regulations. That was a quantitative issue, and it is issue number 8. The above categorization of the issues is made due to the fact that issues 1 to 7 seem not to raise questions concerning tally, results, or the count relative to the numerical outcome of the election. Instead, they are concerned with the process, issues of integrity, custody, interference, and the propriety of the general conduct of the election. Issue number 8 appears to straddle the twin questions of exclusion of agents and violation of legal requirements on the one hand, and also that of counting and tallying of votes. These are issues of both qualitative and quantitative nature, so issue number 8 actually straddles both. Is there somebody who wants to speak? I've also explained how the respondents dealt with their issues. Analysis and determination. Before commencing analysis of each of the issues, it is apposite to discuss the legal basis of the qualitative and quantitative nature of the elections in general. And I start with making reference to a paper by Justice Professor Otieno Odek, the late Judge of Appeal, titled Election Technology, Law and Concept of Did the Irregularity Affect the Result of Elections, published in 2017, where he argues that whereas Article 81 is essentially qualitative, Article 88 of the Constitution is primarily about the quantitative aspect. The requirement for an accurate, verifiable, and accountable electoral system imposes a qualitative assessment of the electoral results. The concept that elections must be free from violence, intimidation, improper influence, and corruption buttresses the qualitative aspects of the electoral process. Equally, the requirement that the electoral process must be transparent and administered in an impartial, neutral, and efficient manner is also qualitative in nature. Let me not quote the whole of it, but he also makes a reference to the William Kabogo case, where Justice Kimaru had something to say about the qualitative nature of an election. He also quotes Justice Lenaola, as he then was, in Masaka versus Kalwale and two others, a 2011 case. And I will not read the citation, the quotation. The initial judicial interpretation of the post-2010 electoral framework was articulated, as we all know, in Raila Amolo Odinga versus IEBC. That's the 2013 case. And then in Raila 2017, the Supreme Court consolidated in Raila, both non-compliance with the constitutional electoral law and that such non-compliance affected the result of the election were taken into account for purposes of nullification of an election. In 2017, there was a shift so that the qualitative approach alone could invalidate the election. But in Raila Odinga 2017, there was an extension that to the effect that when reading together Articles 81 and 86, the validity of an election is not exhausted by the correctness of the declared result, which is what seemed to be the position taken by the first to third respondents, but extends to the integrity of the entire chain through which the result is produced, which appears to be what the petitioner's position was. Placed into the context of the Mbere North by-election, I have found that there's a lady called Weveti, very popular in Embu County, perhaps one of the most common names, so I've taken her as Wanjiko. I thought if I used Wanjiko here, it might be an affront to Weveti. So, placed into the context of the Mbere North by-election, Weveti, a proverbial peasant farmer in Embu County, has political rights under Article 38 of the Constitution. Sub-Article 2 of that provision gives her the fundamental right to free, fair, and regular elections based on universal suffrage and the free expression of the will of the electors. This right may be realized only if IEBC can ensure that the voting system used complies with Article 86, which I will not quote, but it is here in the judgment. The Constitution has also laid out the general principles on how the electoral system and process in Kenya should operate. This is provided under Article 81, which I have quoted, and the key parts I wanted to mention here were the universal suffrage, based on the aspiration for fair representation and equality of the vote, free and fair elections, secret ballot, free from violence, intimidation, improper influence, or corruption, conducted by an independent body, transparent, and administered in an impartial, neutral, efficient, accurate, and accountable manner. So to achieve Waveti's rights, the Constitution established IEBC as the sole organ mandated to conduct elections. The functions and powers of IEBC are set out in the following terms. Under Article 88, this, 88.4, I'll refer just to the fact that the Commission is responsible for conducting or supervising referenda and elections to any elective body or office established by the Constitution and any other elections as prescribed by an Act of Parliament. There are other functions that it is given, which I will not point out at this stage. In addition to these, I can mention one or two others that I've highlighted. There is also the facilitation of the observation, monitoring, and evaluation of elections, a role of the IEBC, and the development of a code of conduct for candidates and parties contesting the elections, also a role of the IEBC. In addition to these powers, which are contained in parts 1 and 2 of Chapter 7 of the Constitution, the IEBC is named as one of the commissions which has the following additional seminal powers. The power to protect the sovereignty of the people, Article 249(1)(a), the power to secure the observance by all state organs of democratic values and principles, Article 249(1)(b), and the mandate to promote constitutionalism. The IEBC is also vested with extremely significant constitutional powers under Chapter 15. That is Article 251, which is as follows. Each commission and each holder of an independent office, A1A, may conduct investigations on its own initiative or on a complaint made by a member of the public. And D, may perform any functions and exercise any powers prescribed by legislation in addition to the functions and powers conferred by this Constitution. In addition, Article 253 constitutes the IEBC as a body corporate with perpetual succession, capable of suing and being sued, which means that it has institutional teeth and can do more than wring its hands when parties and powerful players run roughshod over Waveti's rights. The functions of IEBC are also clearly spelled out under Section 4 of the IEBC Act, and I will not cite them all because they are a fair replica of what is in the Constitution. The wide-ranging powers of IEBC are extended under national legislation. For example, under Section 107 of the Elections Act, which mandates the Commission to prosecute offences under that law. The provision states a member of the Commission or any officer designated by the Commission may order the arrest of a person who commits an offence under the Act. The Commission shall have the power to prosecute any offences under this Act and impose sanctions against a person who commits an offence under this Act, pending the hearing and determination of the offence. A member of the Commission or any person designated by the Commission shall have the power to impound or to order the impounding of any state resources that are used in an election campaign. From the provisions highlighted above, there is no doubt that the IEBC can avert or preempt continuance of certain behaviors of political parties or contestants through arrest, prosecution, or the impoundment of state resources used during election campaigns. The law is abundantly clear that the IEBC need not wait for a complaint or for any prodding in order to exercise any of its powers in the pursuit of a transparent, impartial, neutral, efficient, accurate, and accountable election. There is nothing in the law to suggest that use of these substantive IEBC powers is exercisable only on election day or is limited to only the area within 400 meters, within the 400-meter radius of the polling station set out in Regulation 63(6) of the Elections Regulations. The power to maintain order within that radius inside the polling station is vested directly on the presiding officer himself. However, IEBC, as the Commission, is itself not limited to that radius in exercise of its powers to ensure a free and fair election. Therefore, it is paramount that if any incident occurs anywhere during the election period which would hinder proverbial Wamuthende from reaching or accessing the polling station, or which endangers her life or intimidates her such that she is unable or unwilling to cast her vote, or which corrupts the electoral process or system through bribery, interference, or in any other manner that affects her right to vote, it is the duty of IEBC to diffuse or avoid any such incident. This it can do on its own motion or upon application by any citizen through its provided mechanisms. Indeed, during the election period, the IEBC additionally has the police at its disposal, and it should be an easy thing for it to supervise or conduct elections in the transparent, accurate, free, and fair manner stipulated by law. On the IEBC's powers of prosecution and arrest set out under Section 107 of the Elections Act, the court is aware that it is generally propounded that only the DPP has this power, prosecutorial power. However, Parliament is constitutionally empowered under Article 157(12) of the Constitution to confer such prosecutorial powers on any other authority other than the DPP, as it has done in this case in the Elections Act. Parliament's power under that article is clearly worded as follows: Parliament may enact legislation conferring powers of prosecution on authorities other than the Director of Public Prosecution. How can the IEBC enforce its mandate? To ensure a good quality election, and particularly in this case in Mbeere North. The Mbeere North election period started on 11th August 2025, ended on 1st December 25, when the gazettement of notice of vacancy was published, and gazettement of declaration of the person elected was also published. The election period is defined under Section 2 of the Elections Act and means the period between the publication of a notice by the Commission for a parliamentary election under Section 16 and the gazettement of the election results. As such, IEBC's critical focus on enforcement of the measures necessary for a transparent, free and fair election are expected to be heightened during the election period. One of the ways provided for enforcement includes the Electoral Code of Conduct found under Schedule 2 of the Elections Act, as contemplated under Section 110 thereof. This provision obliges every political party and every person who participates in an election or referendum under the Constitution and the Elections Act to subscribe to and observe the Electoral Code of Conduct. Unless the political party and the candidates have subscribed to the Electoral Code of Conduct, they may be excluded from participation. Unless the political party and the candidate have subscribed to the Electoral Code of Conduct, they may be excluded from participation in the election in terms of Section 110 of the Elections Act. For this purpose, paragraph 15 of the Code requires IEBC to establish an enforcement committee. Significantly, in order for IEBC to ensure a free and fair election, it is incumbent upon it to rigorously enforce the Electoral Code of Conduct, which every party and candidate is obliged to subscribe to. The Code mandates IEBC to entirely exercise the measures under paragraph 7 of the Electoral Code of Conduct in the event of infringement. The measures are summarized as follows: amongst others, to issue formal warnings, to issue fines, which shall be registered in the High Court, to prohibit a party from using media time, issue prohibitions for public meetings, demonstrations, or marches, either on its own motion or in consequence of any report made to it, to institute proceedings in the High Court as may be appropriate in the case of any alleged infringement of the code by a political party or by the leader or office bearer of any political party. From the foregoing, it is clear that there is no shortage of power or legal means vested in IEBC to enable it, whether inside or outside the polling station, during an election period, to deliver a constitutionally sound, free and fair election. It is indeed in the public knowledge that during the election period in Mbeere North, the IEBC's Electoral Code of Conduct Enforcement Committee was functional. I found a case, complaint number IEBC ECCEC number 4 of 2025, which was conducted in Nairobi, where a 5-person committee reached a verdict on 17th November 2025. So IEBC's Electoral Conduct Committee was live and well in 2025, November 2025. It is not novel to suggest that IEBC must take a robust and active rather than passive role in ensuring discipline and a level playing ground during the elections period. In India, the Election Commission in its earlier days neglected to act proactively, despite, like Kenya, there being a code of conduct in force. In a book entitled How India Votes, Election Laws, Practice and Procedure by V.S. Rama Devi and S.K. Medirata, it was observed as follows: rarely, and I quote, rarely was any punitive action taken by anyone if any breach of the code was observed. It was only from the time of the 10th general election to the House of the People in 1991 that the Election Commission became proactive to ensure the observance of the Model Code. In its true letter and spirit by all concerned, the Commission expressed its open displeasure over the conduct of certain high dignitaries violating the Model Code and censured a few officers on that count, and that had the due sobering effect on the others. I have quoted several instances where the Indian Electoral Commission cited parties or candidates. Maybe I can put just one, just for the purpose of illustration. The authors cite an example of a chief minister of Punjab who, during the election to the Madhya Pradesh Legislative Assembly, used the state government aircraft for going from Chandigarh to Indore. I know these names mean nothing to us in Kenya, but they are real places in India. On some official visit. And from there proceeded to Bhopal on an election visit. He was made to pay to the government at the asking of the Election Commission for the entire air journey from Chandigarh to Bhopal and back for his use of the government aircraft in violation of the Model Code. And there's another example too. This is the background I have given, and on that background I now analyze and determine the issues. Issue number one: whether there was irregular, opaque, and unlawful appointment and dismissal of presiding officers in violation of the Constitution and the elections general regulations. The petitioner in paragraph 23 of his supporting affidavit complained that the first respondent trained a set of officers to be appointed as POs and DPOs, but these were not the people who were eventually appointed and deployed. As a result, there was opacity in the appointments. In cross-examination by Mr. Mwangela, PW1 admitted that he was not aware that some of the trained officers were eventually appointed as clerks. PW3, Grace Joy Gaki, the key witness on this issue, stated that she was one of the persons selected by IEBC for a 4-day training for POs and DPOs, that there were 39 trainees, that she was assessed by IEBC and scored 89 points. On the last day, 20 names were read out and she was amongst them. However, she was not given an appointment letter and was removed from the list of those deployed. At the election, she said she voted at Kanyuambora. On cross-examination, she stated that there were a total of 356 trainees. She denied that she was dismissed for failing to attend some parts of the training. She said that she had been verbally assured that she would be deployed as a PO or DPO and was called upon to remain on standby in the event that a deployed officer failed to turn up. In further cross-examination, she said that her non-deployment did not affect the election. She admitted that she was paid for the 4-day training. In re-examination, she stated that she was discriminated upon by not being deployed for alleged lateness, whilst others who were late were deployed. When cross-examined about training and deployment of officers, RW2 and said that PW3 did not complete the training or that she absconded. To this point, this point was explained to her amongst 20 other trainees who were also dismissed. He asserted that PW3 did not complain at the time and that he heard about her complaint for the first time through the petition itself. For the allegation under this issue to have been proved, the petitioner was required to identify the offices in question and demonstrate that there was something irregular, opaque, or unlawful about the appointments, deployment, or dismissal of the officers trained by the IEBC for the purpose of this election. The petitioner was also required to show which provisions of the law were violated and by what acts or omission they were so violated. The evidence of the petitioner did not list the trainees. It did not identify which of the trainees were opaquely or irregularly appointed and or deployed or dismissed, and did not specify which provisions of any law were violated. The petitioner also failed to draw out any evidence through cross-examination of the respondent's witnesses that would have supported his claim on this issue. The petitioner's key witness, that is PW3, considered that her own non-appointment had no effect on the conduct of the election. In light of the above, and as earlier indicated, the issue under consideration concerns the qualitative nature of the election. However, based on the evidence availed, I find that no qualitative disqualifying attribute in appointment and dismissal of IEBC election officials was demonstrated. Issue number 2, whether alleged failure to deploy the printed register of voters resulted in unlawful disenfranchisement of duly registered voters. The petitioner's claim, can you get me some water, please? The petitioner's claim on this issue was underpinned on Regulation 69 of the Elections General Regulations. That provision is as follows, and I'll just go to 1C. Before issuing a ballot paper to a voter, an election official shall call out the number and name of the voter as stated in the polling station register. D, require the voter to place his or her fingers on the fingerprint scanner and cross out the name of the voter from the printed copy register once the image has been retrieved. I think this was the basis of the complaint. On its face, this provision requires that a voter, prior to voting, should produce an ID document to an election official who would then ascertain that the voter has not voted in that election, calls out the name of the voter as stated in the station's register before he then places the voter's finger on the KIMS scanner. Where the KIMS identifies him, the officer crosses out the voter's name from the printed copy of the register. Where the KIMS fails to identify the voter, a verification process to identify the voter has to take place, under which the agents and candidates are involved in identifying the voter using the printed register and completing verification form number 32A. The respondents argued that the requirement for use of a physical register at the point of voter verification was obviated according to the jurisprudence in the cases of UDA and NASA. A brief background is necessary to understand the role of the physical register. In Raila Odinga versus IEBC 2013, the petitioners challenged the integrity of the voter identification process after the electronic voter identification devices failed widely on polling day. The petitioners argued that the IEBC had improperly relied on multiple registers, including the biometric voter register, the Green Book, and the special register for voters whose biometric data could not be retrieved electronically. The Supreme Court rejected the challenge, holding that the principal register of voters was legally capable of existing in multiple integrated forms, and that the use of the manual fallback mechanisms following technology failure was legally permissible in order to prevent disenfranchisement. That decision was the first judicial recognition that technological failure cannot constitutionally extinguish the right to vote. Given the provisions of Section 69 of the Elections Act, the physical register therefore emerged as a necessary backstop mechanism within the electoral process. In addition, judicial interpretation of Section 44A of the Elections Act in relation to voter identification occurred in the NASA National Super Alliance case of 2017. There, the petitioners argued that voter identification and transmission of results ought to be conducted exclusively through electronic systems, and that the existence of manual fallback mechanisms created opportunities for electoral fraud. The High Court rejected that argument. Upholding the High Court, on appeal, the Court of Appeal acknowledged that the Kenyan electoral framework contemplated an integrated electronic system for voter registration, identification, and transmission of results. In essence, the court determined that the complementary mechanism contemplated under Section 44A was intended to operate precisely when the integrated system failed as follows. To our mind, what was required of the respondent was to put in place a mechanism that would complement the one set out in Section 44 of the Act. The particulars of the mechanism, whether electronic, manual, or any other mode, was not expressly provided for in Section 44A. If that were the intention of Parliament, nothing would have been easier than to specify so. The NASA case is significant in that it rejected technological exclusivity and instead asserted that the law contemplates the primacy of technology supported by fallback safeguards intended to preserve enfranchisement where technology fails. The Supreme Court's reasoning directly informs the interpretation of Regulation 69(1)E, which sets out the statutory sequence for identification for when there is identification failure. First, biometric identification, followed by alphanumeric search, and finally resort to the printed register. The NASA case confirms that Regulation 69 is a procedural expression of Section 44A's constitutional complementary mechanism. In Raila 2017, the petitioners challenged the integrity of the election on the basis of failures in electronic transmission, verification, and accountability. Although the Supreme Court did not nullify the election specifically on voter identification grounds, the decision fundamentally altered Kenya's electoral jurisprudence by emphasizing that elections must be transparent, traceable, auditable, accountable, and independently verifiable. The court repeatedly stressed that constitutional compliance depends not merely on whether votes are cast, but whether the process through which they are cast, identified, recorded, and transmitted can later be verified through documentary and technological audit trails. The principle later became central to both the Regulation 69 identification cases and Regulation 72 assisted voter cases. Then I refer to the Maina Kiai case, and I'll skip directly to, because it's taking us long to get there, I skip directly to UDA, the UDA case. On the eve of the 2022 general election, let me just mention, the Maina Kiai case, Kenya Human Rights Commission versus IEBC. It is important. In that case, the petitioners challenged IEBC for issuing a directive proposing to abandon the printed register entirely and rely exclusively on KIMS-based identification. The High Court, building on the NASA case and the constitutional principles articulated in Raila 2017, quashed the directive and held that the printed register was not merely administrative, but a constitutional safeguard. The court found that abandoning the manual register violated Articles 38 and 86 of the Constitution. However, on the eve of the election, 2022 election, the Court of Appeal intervened through the case of UDA versus Kenya Human Rights Commission and others. It stayed the High Court's directive requiring immediate universal deployment of the manual register. It did so without rejecting the legitimacy of the complementary mechanism. Instead, the Court of Appeal held that the following sequence governed voter identification. First, biometric identification through KIMS. Second, alphanumeric search where biometric verification fails. And finally, resort to the printed register only after confirmation of KIMS failure beyond repair or replacement and with the Commission's authorization. The court therefore accepted the constitutional necessity of the manual register while insisting that its use remain controlled and sequential. The Supreme Court applied this hierarchy directly in Raila Odinga 2022, where the petitioners alleged widespread KIEMS failures and argued that the resulting identification process was unverifiable. The Supreme Court upheld the election, finding that although KIEMS kits failed in 235 polling stations affecting approximately 86,889 voters, the IEBC had properly implemented the fallback mechanism through Form 32A documentation and manual identification procedures. It concluded that the integrity and verifiability of the identification process had been preserved, notwithstanding the technological failures. So Raila 22 confirms that technological failure is not fatal in itself fatal, and that matters constitutionally. What matters constitutionally is whether the fallback process remains documented, traceable, and verifiable. In that case, the election survived because the fallback process was properly documented through Form 32A. I've cited a couple of cases on scrutiny from the High Court, which I will not point out, which I'll not read out. But let's go to the evidence now. The evidence in the present case comprised largely of assertions that the petitioner's agents had not seen the physical register at the polling stations. PW1 stated that there was no manual register at the polling stations. PW2, the petitioner's chief agent, gave contradictory evidence on this issue, stating that he did not see a manual register in any polling station that he went to, and no agent told him that they saw a manual register. That the agent at Kitiburi polling station told him that some people were voting even though they were not identified by KIEMS. In cross-examination by Mr. Mongela, however, he stated that he did not witness any KIEMS kit malfunction, and the agents did not tell him how KIEMS kits were started. He also stated that he was not present when KIEMS were being started, but he was shown how the kit was started. He did not recall seeing a QR code on the manual register. PW3 Joyce Gaki, in evidence in chief, stated that she did not see any manual registers on polling day. When cross-examined by Mongela, she stated that during the IBC training, she was told that manual registers would be used only when necessary, like when identifying a voter. When she voted, however, she was identified by KIEMS, and so there was no need to refer to the manual register. PW4, one of the petitioner's polling agents, stated that the voters who were not identified by KIEMS kits were photographed and shown where to vote. He stated in cross-examination by Mr. Mongela that I saw KIEMS being started, I saw the KIEMS kit take a picture, I know it was a picture on voters' register, KIEMS worked from 6 a.m. till closure. In re-examination, he stated that people who are not identified in KIEMS were photographed holding an ID. RW1 stated that KIEMS kits were started through scanning the QR codes on the physical registers. In all the polling stations, he did not receive any reports of complete failure of KIEMS kits being unable to identify a voter. That the physical register is used only when KIEMS fails completely, and in such cases, use of the physical register must be authorized by IEBC headquarters. In cross-examination by Mr. Gashuba, RW1 stated that the petitioner did not specify any station without a physical register. When cross-examined and referred to paragraph 39 of his affidavit, the witness said that the physical registers were deployed 100%. He stated in cross-examination by Mr. Njiro that KIEMS cannot start without scanning the QR code on the physical register. That the register used was the same one used in the 2022 election. RW2 stated in evidence in chief that a physical register was deployed in each polling station. RW3, the PU at Kitiburi 2, stated that I had a printed register of voters which I scanned the QR code to start KIEMS. I did not use the register of voters since all voters were identified by KIEMS kit. RW4, PO at Kitiburi number 1, stated in cross-examination by Mr. Gashuba that she did not use the register of voters except to open the KIEMS kit. RW8 was a PO for Muchonoke polling station. He stated that he had a physical register on polling day and that no voter was turned away. He stated that the register was sealed in a clear plastic paper and it remained that way all day. He did not know how many pages the register had. The top of the register indicated the number of the voters in it, but he did not open it to verify the number of voters in it. During scrutiny, when ballot boxes were opened, the DR noted that in each box there were voter registers wrapped inside a transparent sealed plastic bag. The physical register had on its face a QR code which was used to open the KIMS kit when scanned. Once the KIMS kit was opened through scanning, the kit gained access to the soft copy content of the physical register in the paper bag. Further, when doing the scrutiny, the DR unsealed the physical registers, scrutinized and placed them side by side with the 2022 register and confirmed that they were identical in that they contained the same voters' names. In conclusion, it is demonstrated by the evidence that there was a physical voters' register available at every polling station, that they had QR codes on them to open the KIMS kit at the polling station. The voter register contained in the KIMS was a soft copy replica of the physical register which had the QR code. No evidence was availed that any voter was disenfranchised since the physical registers were present and were also replicated inside the KIMS kit. The prevailing jurisprudence on use of physical registers is the UDA case, which is that such a register is only to be used in instances where biometric or alphanumeric identification fails. There was no evidence of such failure of identification. Had there been failure of biometric and alphanumeric identification, followed by failure by IEBC to deploy the physical register, a case of voter disenfranchisement would have been made out. So that issue also fails. Issue number 3, whether there was unlawful third-party interference with voter registration data and failure by the first respondent to secure and protect the register of voters. There are 2 key complaints sought to be demonstrated by the petitioner's evidence concerning interference with the voter register. These were as follows. Evidence of unlawful interference concerning registration of Collins Monene in Bere North from Ruiru. And B, the alleged transfer of Cecily Mururi Njage from Bere North to Karatina whilst the register had been frozen. PW1 stated that Collins Monene did not appear in the 2022 register and that he was not a voter in Bere North. Collins Monene was not called to testify. In response, RW5, Edwin Ibrahim Golicha, IEBC's voter registration officer at Ruiru, stated in paragraphs 3, 4, and 5 of his affidavit, through an open KIMS kit, a registration official at IEBC can register a voter at any registration center within the Republic of Kenya. That on 8 October 2025, I registered Collins Muriuki Monene as a voter through use of an open KIMS kit at my Ruiru constituency office. That the said error occurred due to human error on my part and was not intended to favor any candidate during the conduct of the by-election. In his oral evidence, RW5 stated as follows. On 8 October 2025, I was overwhelmed by a large number of youthful voters. In the process, I made a mistake of registering Collins Monene. As soon as I realized the mistake, I reported to ICT, the ICT of IEBC. Monene had appeared before me that day. I realized he was registered. I don't know if he could have appeared on KIMS. Collins was the only one I registered. In cross-examination by Mr. Ndegwa, W5 stated as follows. What I did amounted to an alteration. All registers had been frozen as at 22nd June 2022. I was aware of this. It is an alteration. I had no authority to alter the register. I did inform ICT. I did not inform the Commission itself. Section 33, I think the reference was actually to Section 3, but on the record it shows Section 33 of the Elections Act was then read out. RW6 was Paul Wachanga Mugo, ICT officer at IEBC. He stated that he was informed of a discrepancy between the physical register and KIMS, that the former had 399 registered voters while the latter had 400. He asserted that the discrepancy was caused by inadvertent human error by a registration officer at Ruiru, resulting in one extra voter. In cross-examination, he stated that Collins Munene was registered as a voter on 8 October 2025 and that he was alerted by the Assistant Registration Officer RW5. Once he was told, he checked in the system and flagged out Collins Munene. That meant he highlighted Collins Munene as a new entry, since one cannot remove the name but can only flag it out. In cross-examination by Mr. Njiri, he stated that even though the register was frozen for purposes of the by-election, an open kit can register voters anywhere in the country. He did not audit the register to find any other unauthorized registrations. When cross-examined by Mr. Ndegwa, he admitted that such registration affected the character and integrity of voter registration. During scrutiny, the DR made the following findings regarding the issue of Collins Munene under paragraph 414 of the supplementary report dated 22nd April. I quote, according to the KIMS logs and total registered voters, according to the KIMS logs, the total registered voters is 400, whilst according to the 2022 register of voters, registered voters are 399, and according to the 2025 by-election register, the total voters registered is 399. The discrepancy was noted down in the polling station diary at page 30 by the PO. The same is also noted in the initial DR's report filed on 17th April 2026. It further quotes that number 154 on KIMS logs indicates the name Muriuki Collins Munene, yet on both the 2022 and 2025 registers, number 154 is Mutala Daniel Muema. Therefore, Muriuki Collins is not in the two register of voters. The petitioner was interested in knowing whether Muriuki Collins Munene voted in the by-election. The same was checked in the KIMS logs, voter register using the national ID number, and the result was Muriuki Collins Munene did not vote in the by-election. PW5 Cicely Mururi Njagi stated that she had been a voter at Gikuyari polling station since the year 2022. She said she was unable to vote in the 2025 by-election as she could not be identified through KIMS. She was instead informed that she is a registered voter at Karatina. However, she asserted that she had never transferred her voting station. When she checked on the online IEBC portal in her phone, she found that she was indeed registered in Karatina. During scrutiny, the DR noted in paragraph 4 of the supplementary report as follows regarding the case of Cecily Njagi. The petitioners asked to check out the status of one Alex and Cecily Mururi Njagi. Both ID numbers are retained in the hard copy of the report to confirm of the DR's report to confirm whether they were in the register of voters 2022, KIMS register, and KIMS logs. The findings are as follows. Cecily was not present in both register of voters 2022 and 2025 for Gikuyari polling station and KIMS biometric register. Her national ID number appears at 0710 AM on KIMS logs under the citizen ID number so-and-so on 27th November 2025. Voter ID belonged to a polling station number so-and-so, which is Nyeri County, Mathira constituency. So she was not present in the voters register. With regard to Alex, which is not necessary in this case, he was not present in both the 2022 and 2025 register of voters. I'm only reading this because it's in the report and the petitioner had asked during scrutiny. Both never voted in Gikuyari polling station. From the evidence above, particularly the admissions of RW5 and RW6, the following conclusions are inevitably drawn. One, that an IEBC registration officer using an open KIMS kit can register a voter anywhere in the country for a constituency. Two, that an open KIMS kit can override the freezing of a register in an area scheduled for an election. It is also concluded on the issue at hand that there was no proof availed that the admitted interference with the register was either widespread, systemic, or intended. In substance, therefore, there was no proof, and thus no finding can be made, of the fact that the stated interference with the register affected the will of the people. Issue number 4, whether there was violence, intimidation, and disruption of voting in violation of the Constitution, the Electoral Code of Conduct, and electoral law. Incidents of violence were primarily shown through evidence to be significant at Kaungu polling station. PW1 testified that he was informed of incidences of violence, voter intimidation, and disruption of voting at various polling stations. He stated that at Kaungu, the Embu County Governor and the fourth respondent forced their way into the polling station and chaos erupted. That the aides accompanying state officers fired shots in the air. He was shown videos titled Violence Shooting Victim, which had been admitted in part, and CS Roko Voter Agitation Kanyuambora. These are two videos. PW1 was not present at Kaungu at the time. PW8, James Mureithi Njage, who stated that he voted at Kaungu polling station, he said thereafter he left the station and was standing outside the gate of the polling station waiting for his friend. While standing there, he was shot on his upper arm. He reported to the police that he had sustained a gunshot wound before going to Embu Level 5 Hospital, where he reported the nature of his injury. Dr. John Mwangi's medical report indicated that the witness reported that he had been shot. Produced in evidence, there are handwritten doctor's notes showing that he had reported a shot wound and that there was a slight crack in the distal end of his radius. RW7, Paulino Nthiga Njeru, the PO at Kaungu polling station, stated that he witnessed violence from a distance outside the polling station, including stones thrown into the polling station. Voters were aggravated, so he stopped the election process for 30 minutes. When he reopened, the voting continued, but the voter turnout was lower than the earlier turnout. He recorded as follows in the polling station diary. Quote, "The locals and some politicians disrupted the polling process where some window glasses for the polling station were broken. Voting was disrupted between 13:45 hours and 14:15 hours. Action taken, the aperture was sealed at 13:45 hours. All election material and officials were put under tight security. The RO ensured there was backup security." In cross-examination by Mr. Njiri, he stated as follows concerning the incident of invasion into the polling station at paragraph 9. "I say there was a shooting incident. Shown page 345 of the PSD. He says, I recorded that there were politicians. I don't know which politicians. I do not know their names. The politicians and locals affected the polling by stoning the classroom. We had to stop the process of polling. The shooting was past noon. Yes, the number of voters reduced." PW6 was shown a video titled Armed Goons Gitiburi Unattended. It concerns the period after the fire at Gitiburi 2, and there are crowds with some of them armed with sticks. The video titled Gitiburi Path Violence 001 also shows agitated people armed with sticks confronting the IEBC officers after the fire had occurred at Gitiburi polling station. On viewing the videos, the court notes as follows that the most significant violence was experienced at Kaungu polling station. The video showed vehicles like Prados and Land Cruisers without number plates driving out of the polling station with hordes of people armed with sticks, jeering angrily and demanding their removal. At Kaungu, there is evidence of PW8 who testified that he was shot outside the polling station. There is no doubt that whilst Kaungu was the epicenter of the violence demonstrated in this case, there were instances of disruption and commotion wherever any unusual event occurred, such as a fire or attendance of politicians at polling stations in unmarked vehicles. As to whether this violence has a substantial effect on the outcome of the election, the findings from the supplementary report dated 22nd April 2026 indicated that at Kaungu, from the opening of the polling station at 6 a.m. up to 1 p.m., the voter turnout was 347 voters. From 1 p.m. up to close of polling at 5 p.m., not forgetting that the violence occurred at around lunch break at around 1:30, the voter turnout declined to 49 voters. This is clearly shown in the highlighted row in number 2 on table 3, which I have extracted and put in the judgment. The extract on row number 2 of the table 2 shows as follows. Record of voter turnout at the polling station. Details as per the PSD. Total registered voters were 641. Voters who had voted at 900 hours, 177. At 1000 hours, it should be 11 actually, because it goes by every 2 hours. It records every 2 hours. At 1100 hours, 287. At 1300 hours, 347. So between morning and 1300 hours, the voters were 347. From 1300 hours to 1700 hours, the total voters were 396, which shows that merely 49 people voted in the afternoon. The other witnesses to violence, was witness to violence was PW6, Dan Degwa Macharia, the agent for Safina Party at Gitiburi 2. He said that he traveled from Laikipia to participate as a party agent. He testified that after the fire started, the station was invaded by about 300 outsiders, some armed with sticks, accompanying CS Roko. He stated that the group entered the classroom and took things outside the classroom. He protested against CS Roko commandeering the station, but was handcuffed by police officers who were not uniformed. He was then beaten and detained in a police vehicle until 8 p.m. on that day. He said that he was personally beaten by CS Roko and was later sent away from the station, denying him a chance to witness the vote counting exercise. In cross-examination, he confirmed that the video did not show the ballot boxes being carried, that he saw ballot box aperture being sealed, that he later saw the ballot box being removed from the matatu vehicle by the presiding officer and his assistant, that he could not tell if seals were broken, and that the ballot boxes were taken to Stream 1. He did not report this incident to the police. Taking into account the evidence adduced concerning violence as a whole, the court is not able to find that such violence was widespread beyond Gitiburi and Kaungu stations, or was systematic or pervasive within the electoral area or constituency. I'm talking about the evidence. I'm not talking about the allegations. It's the evidence. That is where the weakness of your case was. It's the evidence. The court relies entirely on what is brought into court. So if there are 500 other people, and I know the people of Embu may be feeling something about this, there may have been 500 other people who faced violence. It is possible. But unless the evidence comes into the courtroom and those people testify, proof is not there. The court goes by what is provided as evidence. I was where? Taking into account the evidence adduced concerning violence as a whole, the court is not able to find that such violence was widespread beyond Gitiburi and Kaungu. In fact, in Gitiburi, the only evidence that was provided of violence was Ndegwa, Dan Ndegwa, who said he was beaten by the CS. Then, of course, there were the incidents of the commotion and people with sticks, but that was not indicated as violence. I am not persuaded in the circumstances that the violence substantially affected the overall result of the elections. Despite this, though, there is no doubt that after The violence occurred at Kaungu. There was a decline in voter turnout from about 347 voters between 6 a.m. and 1 p.m. to 49 voters between 1 p.m. and 6 p.m. The voter turnout at Kaungu being 53.9%, compared, for example, to Gitiburi, where there was a turnout of 66.5%, and compared to Gitiburi 2, which had a turnout of 61.8%. This is compared to the average constituency voter turnout of 61.92%. So Kaungu achieved 53 instead of the average 61. If we do a calculation, theoretically, we can say Kaungu may be said to have suffered a turnout decrease of about 8%. 8% or 51 votes or voters, as against the constituency average. So on that issue, again, the petitioner fails. Issue number 6, whether there was bribery, treating and undue influence in violation of the Election Offences Act and the Constitution. PW1 stated that he received reports about serious cases of bribery at Kune, Kageri, Itira, and Kianamu polling stations. He also alleged that bribery was connected to the high numbers of assisted voters. However, he was not able to give any concrete direct evidence of bribery. PW2, the petitioner's chief agent, received reports of bribery at Riandu polling station and treating of voters with unga and cooking oil at Makunguru polling station. He highlighted a person called Nthiga Ndawa area who was allegedly involved in bribery, but he had no proof that the named person was acting on behalf of the fourth respondent. PW3 testified that she witnessed bribery at Kanyuambora polling station, but gave no further details. PW10, Anseta Wakere Maringa, and PW11, Lydia Mbuya Njeru, were the key witnesses for the petitioner on the issue of bribery. PW10 testified that on the occasion, on the election day, she was called by her former MP, Muriuki Njagagwa, who she knew. He asked her to go to the home of her neighbor, Edward Njage. And when she got there, she found many people and was informed that there were presents available for them. She saw those items in Edward Njage's home where Njagagwa was. They were then each given 2 kgs of maize flour, wheat flour, and rice, and Kenya shillings 500. The items were to be in exchange for her vote for the UDA government candidate in the by-election. When she refused to take the items and the money, she was told that she would not benefit, and Njagagwa left the items for them. Shown her affidavit, she said there was no indication that she took any bribe, though she alleged that she saw others taking bribes. In her oral testimony in cross-examination by Mr. Gashuba, PW10 stated as follows: Njagagwa was bribing people. He did it on behalf of Wamuthende. He told us so. I did not see Wamuthende. I took 2 kgs of rice, 2 kgs of ugali, 500 shillings, and unga ya chapati. I ate them. It was not written that they were for the election. I was hungry, so I ate. Others also got, and they ate. Many who couldn't write also ate, and they were helped to vote. I have no affidavits of others involved. Lydia was with me at Edward's house. We were given the gifts together. Cross-examined by Mr. Kamoto, she reiterated, I think this is when Mr. Kamoto spoke the local lingua. You forgot you were in court. Cross-examined by Mr. Kamoto, she reiterated that she indeed took the gifts, that initially she declined, but eventually she took the things since they belonged to the government. PW11, that was, I think, Lydia Mbuya, testified that she was invited to Edward Njage's home where they were offered bribes in the form of food. They were offered the goodies so as to be assisted to vote for the fourth respondent, and that she agreed to vote for the fourth respondent. That is in paragraph 4 of her affidavit. They were told that if any of the invited recipients refused to vote for the fourth respondent, they would not benefit from the gifts. But most people took money and they were swayed to pose as voters needing assistance. In her oral testimony, she said that she was given 2 kgs of sugar, 2 kgs unga, 2 kgs ungangano, and 500 shillings by Njagagwa, who told them to vote for the 4th respondent. Further, PW11 testified that there were 2 ladies and 1 man who were given Kenya shillings 15,000 to find people who would vote for the 4th respondent, and that some of them would pose as assisted voters. She considered that she took the bribes and was influenced to vote as suggested. In cross-examination, she stated that she witnessed bribery outside the gate of the polling station, but she did not report the vice generally. She reasserted that she was bribed and the bribe was intended to influence her vote for the 4th respondent. In the present case, PW10 and PW11 have admitted repeatedly that they took the bribes intended to influence them to vote for the government candidate, namely the 4th respondent. I listened carefully to their evidence, in which they corroborated one another. They did not strike me as incredible, lying, or flippant. I believe their testimony as to the fact that they took bribes. I do not doubt that they were at Njage's house, where they said they were when Njagagwa offered them the bribes. The submission by the petitioner was that the bribery was not only intended to influence the voters to vote for the government candidate, but also enable them pose as illiterate voters needing assistance. However, neither PW10 nor PW11 alleged that they were actually assisted to vote, nor was a single witness brought to testify who was an assisted voter. On this, the IEBC submitted that whilst PW10 knew that she was committing an election offense by taking the bribe from Njagagwa, she did not report the same. IEBC, I challenge anybody to ever report to you that they were bribed, or any briber to report to you that they gave a bribe. There was no witness availed by the respondents to controvert the evidence of PW10 and PW11, although Njagagwa was named in the affidavits, as was Njage. The petitioner invited the court to find that the bribery, treating, and undue influence were offences in violation of the Election Offences Act. However, this court's jurisdiction is to hear petitions under Article 105, which provides as follows: the High Court shall hear and determine any question whether a person has been validly elected as a member of Parliament, or B, the seat of a member has become vacant. Clearly, the constitutional jurisdiction of the election court is limited to making a finding on validity of the election and vacancy of a seat. The court does not sit as a criminal court when conducting an election petition. Thus, the finding this court can make regarding bribery, treating, and undue influence is that prescribed under the Elections Act and no other. In that light, the provision of Section 87(1) of the Elections Act enables the election court to make a determination regarding an electoral malpractice of a criminal nature. The provision, that is Section 87(1), is in the following terms. An election court may, at the conclusion of the hearing of a petition, in addition to any other orders, make a determination on whether an electoral malpractice of a criminal nature may have occurred. This provision merely entitles this court to make a finding as to whether a malpractice of a criminal nature may have occurred, not that it did occur. Further, in an election petition, the election court has no jurisdiction to determine a criminal matter or whether an offense under the Election Offences Act was or has in fact been committed, since that is an issue squarely within the jurisdiction of a special magistrate's court. Such court must be specially constituted by the Chief Justice under Section 23(1) of the Election Offences Act, which provides as follows: the Chief Justice may, by notification in the Gazette, appoint as many special magistrates as may be necessary to hear and determine matters relating to offences under this Act. In light of the foregoing, this court, as an election court, can make a determination only on whether an electoral malpractice of a criminal nature may have occurred in terms of Section 87 of the Elections Act, but not on whether the offence of bribery was committed. I do find that an electoral malpractice of bribery may have occurred. Ultimately, however, the question I must answer on this issue is whether the electoral malpractice of bribery and voter influence so found results in the nullification of the election. From the evidence above, I am unable to find that the scope and prevalence of the malpractice substantially affected the result of the election in terms of Section 83 of the Elections Act. We are talking about two witnesses who said they were bribed. And I only accept their evidence because it was not controverted by the respondents. Issue number 6, whether there was a broken chain of custody, unlawful handling of election materials, and violation of procedure on close of polling. The petitioner made claims of a wide range under this issue, alleging broken chain of custody and unlawful handling of election materials. However, he was not an eyewitness in any of these events, neither was his chief agent, that is PW2. The main evidence that emerged in respect of this issue was that concerning Itiburi Primary School Polling Station 2, where there was a fire, and Kaungu Polling Station, where there was an invasion by unauthorized people. PW6 Dan Degwa, the party agent for Safina Party, stated that he was at Kitiburi 2 when a lamp fell and triggered a fire in the classroom that was set up as a polling station. He said that they rushed out and then he rushed back into the room to retrieve his phone, which was charging there, as he helped put out the fire. He stated that CS Roko came to the station with about 300 people in tow, and they occupied the classroom, that the votes were placed inside the Nissan van, which was left unguarded outside, and he believed that they could have been interfered with. He said that by that time he had been handcuffed on the instructions of CS Roko, and some agents had run away. In his affidavit, PW6 could not confirm what happened at the voting in the classroom, as he was seated at the back observing. In his oral evidence, he reconfirmed that it was about 5 p.m. when the fire broke out, as the PO was attempting to light the gas lamp, or a gas lamp. That bedlam then broke loose, and the crowd of people started coming into the polling station. A video named NNK23 Collection Gitiburi was shown. He said that the crowd comprised of about 300 people, and at the time the ballot boxes were still in the classroom where they were left when the fire broke out. He further stated that locals salvaged the ballot boxes and took them to the vehicle, that the PO and DPO were not in the vehicle when the ballot boxes were taken to it. IEBC officers were called to come and collect the boxes from the vehicle, and they complied and picked the boxes. On further cross-examination, PW6 stated that there were things taken outside the polling station classroom by strangers. He said that he did not see in the video the ballot boxes being carried out by locals to the vehicle. Upon viewing the aforesaid videos, the court noted that as follows: there indeed was a fire, that there was commotion at Gitiburi, that there was involvement of large crowds of people, some armed with sticks, that there was also a van into which some IEBC officials in IEBC reflective vests were seen attempting to enter. However, no ballot boxes were seen in the videos. Hence, the videos do not support the allegation of third parties handling, I'm talking about handling, the ballot boxes. In his affidavit, PW7, Simon Kariuki, a voter at Gitiburi, stated that shortly after the fire was controlled, CS Roko came to the station accompanied by people armed with sticks and rungus, and they took the ballot box to the vehicle whilst beating people. That CS Roko demanded that the ballot boxes be brought to one classroom and ordered that the ballots from both Gitiburi 1 and 2 polling stations be counted together. One of the ballot boxes emerged from amidst the crowd and was given to CS Roko, who gave it to IEBC officials. That CS Roko demanded that the votes that the votes be counted and tallied. He did not witness reopening of the ballot boxes again, and he denied signing forms 35A. He stated that the counting took place in one polling station at Gitiburi. RW4 Jane Karim Induma was the presiding officer at Gitiburi 1. It was her evidence through her affidavit that after the polling ended at 5 p.m., she secured the room before counting started. She confirmed that CS Roko came to the station and caused commotion. She noted that there was a fire at Gitiburi 2, that she prepared the polling station as a counting room. She made no mention of Gitiburi 2 in her affidavit. In her oral evidence, RW4 testified that there was a fire at Gitiburi 2. It led to a commotion because there was a large crowd of people. She took the ballot box and took cover in a vehicle. That vote counting started at 7 p.m., that the votes for Gitiburi 2 were also counted at Gitiburi 1. In cross-examination, she stated that she did not see CS Roko and that he was not involved. She admitted that she hosted another polling station and that no one authorized her to do so. When shown a video of the fire incident at Gitiburi, RW4 confirmed the incident was as depicted in the video. She saw the PO of Gitiburi 2 in the video with people in the crowd holding sticks at the scene. By that time, she said she had secured the ballot box in the vehicle. She said no polling officer for Gitiburi 2 was in the vehicle, but the boxes for Gitiburi 2 were there. On re-examination, her evidence was that after getting to the vehicle with her ballot box and with the security officer, she realized that she had left some personal items in the polling station. She thus left the ballot box in the vehicle to get those items. That was the only time she left the ballot box unattended. RW3 Lydia Kamau was the PO for Gitiburi 2. In her affidavit, she stated that after closing the station, she closed the KIMS and sealed the aperture at 5 p.m. She then called for a short break before counting began. At around 5:30, her deputy, Felix Mwaniki, lit a gas lamp which burst into flames. She managed to secure the ballot boxes. She telephoned Siakago police station and reported the incident and was issued with an OB number such and such. She stated that CS Roko came to the station and that his arrival caused some commotion. RW3 further stated in her affidavit that during the brief incident of the gas lamp explosion, the election materials remained secure. Let me read that again. RW3 stated that when the fire broke out, she took the boxes to the vehicle hired by IEBC together with the security officers and agents. She said that she and her team transferred their materials to Gitiburi 1 to count ballots, and they found Station 1 already going ahead with counting. In further cross-examination by Mr. Ndegwa, she stated that the forms which were burnt were KIMS Forms 32A. From the DR scrutiny report of 17th April 2026, the DR noted that the PSD for Gitiburi 1 recorded the fire incident as follows. Incidents recorded on page 30 as an accidental fire in Station 2 at 17:30 hours. Fire was put out and calm restored. Security backup. In Gitiburi 2, the PSD indicated that the PO recorded gas cylinder exploded and some of the forms were burnt. We were able to secure the ballot papers, ballot boxes, KIMS, and some forms. It is clear from the totality of evidence adduced that in Gitiburi 1 and 2, polling had concluded by the time the disruption arose from the fire and the crowd that invaded the polling stations. That RW4 took cover from the crowd in the vehicle, and at that time the boxes from Gitiburi 2 were in the same van without any officer from the polling station. It was admitted by RW4 that at some point she also left the box for Gitiburi 1 in the van unattended when she left to get her bags which had been left inside the polling station. With regard to evidence on Kaungu, RW7, Paulino Nthiga Njeru, the PO, stated that he witnessed violence from a distance outside the polling station, including stones thrown into the polling station. He then stopped the election process for 30 minutes. When he reopened, voting continued, but the voter turnout was lower than earlier. He recorded in the PSD that locals and some politicians disrupted the polling process when some windows for the polling station were broken. Voting was disrupted between 13:45 and 14:15 hours, and action taken was the aperture was sealed at 13:45. All election material and officials were put under tight security. Thus, for Kaungu, it was the actual polling that was interrupted at 1:45 p.m. and the polling station was closed for 30 minutes. However, there is no evidence that during this time the election materials were removed from the polling station or were outside the PO's control. In summary, the evidence on this issue, we are looking at the issue whether there was broken chain of custody and lawful handling of election materials and violation of procedure of close of polling. In summary, the evidence on this issue is as follows. 1, at Kaungu, despite the fact of disruption of polling, the election materials were not interfered with. 2, at Gitiburi 1, the disruption occurred after closure of the polling station at 17:30 hours as recorded in the PSD. At Gitiburi 2, the disruption occurred after close of the polling station according to the PO. Number 4, at Gitiburi 1, the evidence is that the election materials were left unattended in the van according to the PO. 5, the evidence concerning the election materials at Gitiburi 2 is inconsistent, namely that they were handled by unauthorized persons and also that they were left unsecured or unattended in the van or that they were secured. It is not clear. The evidence is inconsistent. From the DR's supplementary report dated 22nd April 2026, the results in Gitiburi 1, as recorded in the PSD, Form 35 and KIMS, were consistent, save for one ballot paper marked in favor of the fourth respondent with no corresponding counterfoil. For Gitiburi 2, the report shows that the KIMS kit showed that the last voter was verified at 16:55 hours, while the PSD indicated that the polling was closed at 1700 hours. There was one ballot cast in favor of the fourth respondent, but no corresponding counterfoil for it. The totality of the above evidence discloses that for Gitiburi 1 and 2, there was broken chain of custody, possible and lawful handling of voting material, but no violation of poll closing procedure. For Kaungu, there was no evidence of broken chain of custody, unlawful handling of or violation of poll closing procedure. Consequently, there is no basis for finding that the irregularity or non-compliance was substantial and that it affected the election outcome in terms of Section 83(1) of the Elections Act. Had it been demonstrated that the sort of violence shown at Kaungu was pervasive or widespread and occurred during the polling, a positive case would have been made to conclude that the violence affected the overall quality of the election and had a significant effect on the result. Issue number 7, whether there was use of state resources Forces, State Security and Public Office to influence voters, which constituted abuse of power and improper influence in violation of Articles 10, 73, 75. In order to prove issue 7, to provide at least the following evidence: names of the public officers, this date, a number of them, their designations and offices held, and particulars and nature of the alleged abuses of such offices, and the overall effect of such abuses upon the electorate and the election outcome. The petitioner failed to provide these through the evidence adduced, and accordingly, I am unable to find in his favor on this issue. Issue number 8. Whether there was delay in counting votes, exclusion of agents, defective and falsified statutory forms, opaque counting and tallying in violation of Article 86 of the Constitution and Regulation 79 of the Elections General Regulations. With regard to delay in counting votes, the only evidence presented related to Gitiburi 1 and 2 were the breakout of the fire affected the timely counting of votes. Regarding exclusion of agents, the only evidence was that of PW6, who alleged that he was handcuffed and detained in a police vehicle until 8 p.m., hence was denied a chance to witness counting of the votes. From the DR scrutiny reports, agents of the petitioner were present in the stations where scrutiny was ordered, and they signed Forms 35A. With regard to defective and falsified statutory forms and opaque counting and tallying, the allegations in the petition were that Forms 35 were overwritten, resulting in opacity of results. In respect of Kerie Polling Station 2, Nazario Mugo, who was the PO, did not testify on the inconsistencies between Forms 35A and 35B, showing a total number of votes obtained and cast as 225 and 223 respectively, a difference of 2 votes. I looked at the form carefully, the Forms 35. The tally on the right-hand side for each candidate is indicated as in a total. That figure is supposed to be translocated to the column on the left-hand side, and the two should tally. So the key figure that is of interest is the one on the right-hand side, not the translocated figure. In respect of Gitiburi 2, RW3 Lydia Kamau, the PO, did not testify on the inconsistencies between Forms 35A and 35B, which indicated that the number of valid votes obtained and cast is 261 and 262 respectively. However, during scrutiny, the votes were recounted and the number of valid votes cast remained 262, meaning that Forms 35B was erroneous by 1 vote. In respect of Mushonoke 2, Timothy Nyaga Maringa, the PO, did not testify on inconsistencies between Forms 35A and 35B, showing 304 and 303 votes respectively on the number of valid votes obtained and cast. Scrutiny was not done for this station, and the inconsistency of 1 vote remains unexplained. At Kamugu Polling Station 2, Form 35A indicates the number of valid votes obtained as 449, which is where the tally for each candidate is indicated. Whereas in the section of polling station counts, at item 5, the total number of valid votes cast is indicated as 456. This is on the left side of the form, 35. And the total rejected votes are indicated as 7. Shadrach and Nyaga and Jagib, the PO at this polling station, did not testify, and no further explanations were made regarding this inconsistency of 449 and 456 votes. On this latter inconsistency, it appears likely to the court that the 7 votes difference is attributable to the total rejected votes being carried to item 5, and added to the votes obtained. These unexplained inconsistencies in these votes, all these Forms 35 that I've referred to, these unexplained inconsistencies, I should say, add up to 10 votes in Forms 35. Add up to 10 votes in Forms 35A, a difference of 10 votes in Forms 35A and 35B, so that the election result has a 10-vote difference, unknown as to whom those votes would benefit. The scrutiny did not find anything to suggest any irregularity, but rather careless mistake in translocation from the vote tally column of Form 35. 35A, Form 35A. Regarding allegations that some 37 Forms 35A were overwritten and not countersigned, the court allowed scrutiny of only 8 of them where such overwriting demanded scrutiny. The DR's scrutiny report, dated 17th April 2026 at pages 21 to 24, found that despite overwriting, the figures added up to the total valid votes as in Form 35A. There was no major discrepancy noted. The court agrees that the overwriting did not result in any discrepancy and the irregularities cannot be said to substantially have affected the will of the people. The will of the voters, not the people. The petitioner also complained during the hearing about errors on Forms 32 in respect of assisted voters. I have had to deal with this issue because it arose during evidence repeatedly. At the outset, it is essential to note that the issue of assisted voters was not pleaded, either in the petition, in the petitioner's issues, or in the grounds of relief. It featured, however, in the supporting affidavit of the petitioner. In one paragraph, we'll get there, and in some of the other affidavits of the petitioner's witnesses, and also in witness testimony. In paragraph 94 of the supporting affidavit to the petitioner deposed as follows: that further, the said agents would bribe the voters on condition that they declared that they were illiterate and in need of assisted voting. This led to exhaustion of oaths of secrecy forms due to inexplicable influx of persons allegedly in need of assisted voting. The second respondents filed an affidavit in support of the response to the petition. The first to third respondents did not respond specifically to the allegation made under paragraph 94 of the supporting affidavit of the petition, even though on their behalf the second respondent acknowledged as follows: that I have read and been explained to by Charles Benedict Mongela, counsel on record for the first, second, and third respondents, the election petition dated 22nd December 2025 and the affidavit in support of the election petition, sworn on 22nd December 2025 by Dwiga Newton Kariuki, and wish to respond as follows. So the issue became sort of subsumed through the affidavits. In furtherance of his claims on assisted voting, the petitioner during his testimony on numerous occasions reiterated his claim on bribery and assisted voting, which featured in his supporting affidavit. Other witnesses of the petitioner, for example PW10 and PW11, considered that as they were accepting bribes, others in the group and in the premises at the house of Edward Njage, where they were also accepting bribes to become assisted voters. PW9 Julieta Kidhumbu testified that she saw many assisted voters at Muchonoke Health Center 2 polling station, where she was the agent. She said that there were mobilizers who brought assisted voters to the station. In one case, she saw an assister assist 4 voters, and she complained to the PO but did not record the fact in her notebook, though she signed Form 35A without objection. The issue of assisted voters became pronounced after the court ordered that election materials be preserved into the custody of the court and the DR to make a detailed report on the movement. That's the movement of the materials. The record of that movement of materials for preservation is contained in the DR's report pursuant to the directions of the court, dated 15th January 2026, for removal of the election materials from IEBC to Embu High Court. The report is dated 27th January 2026. In it, the DR recorded having received the following boxes from a strong room of IEBC offices in Embu. (134) ballot boxes, namely 1 from each polling station. 1 box captured as the 135th ballot box delivered at the tallying center. 4 boxes recorded in an, quote, inventory of other strategic materials issued to Embu High Court for the Mbeere North by-election petition, unquote. And finally, 15 boxes containing Kim's kits. Of the 4 boxes in the inventory of other strategic materials issued to Embu High Court for the Mbeere North by-election petition, that was box number 114337, it contained, amongst other things, 1,072 Forms 32, declaration of secrecy, made by a person assisting a voter. Naturally, this inventory raised concerns as to why these materials were produced from the IEBC offices at Embu without any record by the returning officer. Accordingly, in its ruling, paragraph 62 and 4, 62, 2 and 4, delivered on 27th March 2026, the court ordered scrutiny of other strategic materials issued to Embu High Court. Following scrutiny by the DR, she reported her findings at page 15 to 19 of her report of 17th April 2026 as follows. That there were 1072 Forms 32, folio marked 1 to 1072. Out of these, 10 were blank or unpopulated in any way, blank forms. There were forms by 6 declarants which had filled forms who, not which, by 6 declarants who had filled forms twice, of whom 2 declarants filled 2 forms at 2 different polling stations, while the other 4 declarants each filled 2 forms at 1 station. That is all contained in table 4 of that report. RW1 testified that at the tallying center, he received 134 ballot boxes. He also stated that he handed over to the DR 135 ballot boxes, with 1 box containing strategic materials. He stated that he prepared box 135 out of good faith. He gave no explanation for any of the other boxes. According to the IEBC polling station diary, template, forms 32 from each polling station. My understanding is that what is required is a continuous balancing between two competing. On the one hand is the cardinal rule on adversarial litigation, that parties are bound by their pleadings, ensuring procedural fairness, certainty of issues, and protection against trial by ambush. On the other hand, there is the constitutional duty imposed on election courts to safeguard the integrity, verifiability, accountability, and transparency of elections under Articles 86 and 81 of the Constitution. It is a substantive rule of adjudication that pleadings have a binding force. In IEBC versus Stephen Mutinda Mule and others, the Court of Appeal stated in unequivocal terms that parties are bound by their pleadings and that evidence which departs from the pleaded issues goes to no issue and must be disregarded. The same logic was reiterated in Raila Odinga and 5 others, Supreme Court Petition number 5 of 2013. There, the Supreme Court emphasized that parties are bound by their pleadings and evidence must be confined to pleaded issues. Similarly, the Supreme Court in Zachariah Okoth Obado and Edward Oyugi, Supreme Court Petition 37 of 2014, reinforced the position that election petitions are strictly framed disputes. Respondents are entitled to know with precision the case they must meet, and the court is equally constrained by the issues framed in the pleadings. This establishes pleadings as the primary jurisdictional boundary of electoral adjudication. Against this strict framework, the Supreme Court in Gatirao Peter Munya versus Dixon Mwenda 2014 set out the governing logic on scrutiny, which is that scrutiny is not a fishing expedition. It is a verification mechanism tethered to pleaded allegations. The court was clear that scrutiny cannot be used to discover new causes of action or to sustain a petition that fails on its pleaded grounds. However, the court also recognized a controlled opening, namely, that where scrutiny is properly ordered, particularly by the court itself, as in this case, what emerges may be interrogated by the parties and evaluated for its impact on the integrity of the result. Can courts therefore ignore serious electoral irregularities that emerge from scrutiny? Where scrutiny is triggered by a party's application, its scope is strictly confined to the pleaded issues and the specific polling stations in dispute. It cannot be used to enlarge the petition or introduce new grounds of challenge. Yes, several cases cited. By contrast, where scrutiny is ordered suo motu, which is I think what this court did, the court may direct scrutiny as part of its case management powers to clarify the evidentiary record, but this does not expand the issues for determination or convert scrutiny into an inquisitorial process. Any irregularities emerging from the scrutiny remain subject to contestation by the parties and must be evaluated within the pleaded issues and the constitutional standard of electoral compliance. The question whether the court should turn a blind eye on malpractices arising from scrutiny was focused on in the Musikari Combo case, 2014, where the court held that an election cannot turn a blind eye to serious electoral malpractices revealed during scrutiny or recounts simply because they were not pleaded. The court justified this exception on constitutional grounds that electoral justice cannot be reduced to procedural technicalities where the process itself is shown to be fundamentally compromised. In Peter Kingara versus IEBC 2014, the Court of Appeal emphasized that scrutiny is not an avenue for building a new case. That position was reaffirmed in many other cases, and I have cited a number of them. The courts have reiterated that scrutiny must remain tethered to pleaded issues unless exceptional procedural safeguards exist. That caution was emphasized also in Walter Nyambati case, 2018, where the Supreme Court stated that scrutiny is not a fishing expedition, cannot be used to latch onto whatever evidence to construct a case not pleaded. I have cited Abdikadir Hussein's case, the 2023 High Court. Kenya Court of Appeal, where the Court of Appeal introduces a decisive procedural safeguard that even where serious irregularities are reviewed by scrutiny, an election court cannot rely on them without first placing the adverse party on notice and affording an opportunity to respond. The court treated this not as a discretionary courtesy but as a requirement of due process, and pleaded material cannot silently or automatically mature into grounds for nullification. In the present case, and as already pointed out, the issue of assisted voters featured significantly in the petitioner's supporting affidavit and upon hearing of the evidence of the petitioner's witnesses. The respondents thus had a full opportunity to deal with the issue. It was evident as far back as was recorded in the DR's report on movement of the preservation materials and in the petitioner's witness affidavits. There was no ambush, in my view. In its decision in Kombe versus Karisa and three others, 2024, Kenya Supreme Court, the Supreme Court affirmed the core principles in Munya on scrutiny. The Apex Court stated as follows at paragraph 107, the Court of Appeal relied on the decision of the Supreme Court in Munya that scrutiny is a vehicle to assist the court to verify the allegations made by the parties to the petition, which allegations themselves must be hinged on pleadings. That it was never intended to enable the court to unearth new evidence on the basis of which the petition could be sustained. From the record, the Supreme Court accepted that the trial court had engaged extensively with scrutiny findings such as unstamped counterfoils, polling station inconsistencies, and irregularities in statutory forms. The Court of Appeal had criticized reliance on some of these matters as unpleaded. The Supreme Court's reaction was not to abandon the pleadings rule, but to recharacterize the function of scrutiny evidence within the broader evidentiary inquiry. It held in substance that scrutiny findings do not operate as stand-alone causes of action, but neither are they legally inert simply because they were not expressly and specifically pleaded. At para 108, the Supreme Court noted as follows, it would appear therefore that the report of scrutiny did not yield the outcome expected by the first respondent when he sought it. That did not preclude him from presenting and relying on other pieces of evidence to illustrate that the election in question did not conform with the constitutional and legal imperatives. In the present case, the question of assisted voters was not specifically pleaded, as already stated. Nevertheless, it does not arise entirely as an ambush. Since the petitioner's supporting affidavit and the first to third respondents' replying affidavits took notice of the issue. When the court ordered scrutiny of the assisted voter forms, this emanated from the fact that they were produced for preservation without any record as to how they found their way into the box and files. They were delivered in. The court was thus entitled to order scrutiny thereof since oral evidence had been taken and no proper account of the Forms 32 had been given by the respondents. Thus, scrutiny was duly ordered and forms part of the evidential matrix. In my view, the outcome of the scrutiny may be used in aid in evaluation of whether the totality of the electoral process met the constitutional threshold of integrity, verifiability, and accountability. The decisive question is not whether each irregularity was individually pleaded, but whether the election, taken as a whole, complied with the constitutional and statutory standards. The authorities hold as follows, and I've cited Mohammed Abdi. Let me read it. Where the Supreme Court majority refined the remedial approach to Regulation 72, non-compliance, by requiring that such breaches be assessed within the broader Article 86 framework of verifiability and materiality, rather than be treated as automatically determinative of electoral invalidity. Where in the first instance the failure to mark the register is isolated or inadequately proved, the courts generally decline to nullify elections, although the failure weakens the credibility of the official account. This was the position in Mohammed Mahmoud Ali versus IEBC, Mombasa High Court 2017. Further, if the failure becomes systemic, particularly in constituencies where assisted voting would predictably be widespread, courts may infer that the process itself became unverifiable. In light of the foregoing analysis of the law, this court can now make the following conclusions. First, that Regulation 72(6) of the Elections General Regulations was violated in respect of the 1072 assisted voters, as they were not recorded in the physical register as required, nor was there evidence that they were indicated as such in the KIMS register or PSD. Secondly, that the only evidence available that there were assisted voters is the existence of Form 32, which is the declaration of secrecy, in compliance with Regulation 72(5), indicating the declaration of secrecy by persons that assisted the said voters. Thirdly, with regard to double declarations by the 6 declarants earlier discussed as found during scrutiny, these were in breach of Regulation 72(5) of the Elections General Regulations, which provides that as follows: the following shall apply with respect to a person who assists a voter under this regulation. The person shall assist or support only one voter at that election and have a mark of as proof of assisting or supporting a voter. Fourthly, while the court take the position that all assisted voters' votes be struck off, it would not change the result of the election, as it is impossible to identify for which candidate they voted. Finally, taking into account the caution of the superior courts concerning unpleaded issues and considering these violations cumulatively with the other irregularities pleaded and on which evidence was availed and has been evaluated, I am not satisfied that it was ultimately shown that the results did not reflect the will of the people in relation to assisted voters. Conclusions and disposition. On issue 1, the court found that the evidence of the petitioner did not list the IEBC officers in issue, did not identify which of the officers were opaquely. Actually, I've just reiterated, I have plucked from the body of each conclusion, I have brought it back to the conclusions and disposition. So that on issue 1, I find that no qualitative disqualifying attribute in appointment and dismissal of IEBC election officials was demonstrated. On issue 2, again, I have plucked the conclusion I reached under that issue and brought it forward. It was demonstrated by evidence that there was a physical register, voters register available at every polling station, that it had a QR code, that the KIMS kit had a soft copy replica of that register. No evidence was availed that any voter was disenfranchised, since the physical registers were present and were also replicated in the KIMS kit. Then I point out the jurisprudence on the use of the physical register is essentially what is carried in the UDA case, that such register is only to be used in instances where biometric or alphanumeric identification fails. The UDA case, I may say, does not entirely deal with Section 72, Regulation 72. It doesn't entirely with regard to assisted voters. There was no evidence of such failure of identification. The prevailing jurisprudence on the use of registers is the UDA case, is that such register is only to be used in instances where biometric or alphanumeric identification fails. There was no evidence of such failure of identification. Had there been a failure of biometric and alphanumeric identification, followed by failure by IEBC to deploy the physical register, a case of voter disenfranchisement would have been readily made out. On issue 3, whether there was unlawful third-party interference, on this I came to the conclusion that it was not proved that admitted interference with the register was either widespread, systemic, or intended. In substance, therefore, there was no proof that of the fact that the sole instance of interference that we saw in the case of Collins affected the will of the people. It was also held that in the case of one individual, where the register was shown to have been unlawfully altered, the officer involved may have committed a criminal offense. On issue 4, the same summary that I take the same summary or conclusion, and this is where I said Kaungu theoretically suffered a turnout decrease of about 8% or 51 voters as against the constituency average, but I found overall the failure did not affect the outcome in terms of Section 81 of the Elections Act. Section 82, of the Elections Act. On issue 5, whether there was bribery treating, maybe I just read all of them, if you don't mind. Let me just read all of them so that I don't give an impression. On issue 5, whether there was bribery treating and undue influence in violation of the Election Offences Act and the Constitution, there was uncontroverted evidence of bribery involving 2 witnesses. As an election court, this court can make a determination only on whether the election malpractice, whether an electoral malpractice of a criminal nature may have occurred in terms of Section 87 of the Election Act, but not on whether the offense of bribery was committed. I do find that an electoral malpractice of bribery may have occurred. As to whether the electoral malpractice of bribery and voter influence so found results in the nullification of the election, the evidence does not show that the scope and prevalence of the malpractice substantially affected the result of the election in terms of Section 83 of the Elections Act. On issue 6, whether there was broken chain of custody, unlawful handling of election materials, and violation of procedure on close of polling, the totality of the evidence availed disclosed that out of 134 polling stations, there was broken chain of custody, possible unlawful handling of voting material, but no violation of poll closing procedure at Gitiburi 1 and 2, except with regard to the time. For Kaungu, there was evidence of violence, but no evidence of broken chain of custody, unlawful handling or violation of poll station closing procedure. Consequently, there is no basis for the finding that the irregularities or non-compliance were substantial and affected the election outcome in terms of Section 83(1) of the Elections Act. Had it been demonstrated that the sort of violence shown at Kaungu was pervasive or widespread, a positive case would have been made out to conclude that the violence affected the overall quality of the election and had a significant impact on the result. Issue 7, on whether there was use of state resources, state security offices to influence the voters. It was incumbent on the petitioner, in order to prove issue 7, to provide at least the minimum information or proof. The names, some of which were provided, their formal designations, the offices held, and particulars and nature of the alleged abuses of such offices, provisions of the law breached, and the overall effect of such abuses upon the electorate and the election outcome. The petitioner failed to provide these through the evidence adduced. Accordingly, the court is unable to find in his favor on this issue. On issue number 8, the same, the court was unable to find in favor of the petitioner, the same on even the assisted voters, because with the assisted voters, what I have done is that I have said I take seriously the caution by the superior courts concerning unpleaded evidence gathered through scrutiny. The outright determination, the overall determination, for all the foregoing reasons, the court finds that the petition was not proved to the required standard, and it is hereby dismissed with costs. The costs are as follows. The parties made submissions on costs, generally to the effect that costs follow the event. The first to third respondents' counsel went into some fair detail in indicating the depth of the case, the number of attendances, preparatory time, complexity, and so on. The first to the third respondents and the fourth respondents both indicated that costs should be at Kenya shillings 5 million. The petitioner only submitted during highlighting. So having considered the nature of the case and the input of the parties and noting the fourth respondent did not testify to or avail witnesses, I hereby cap party and party costs at Kenya shillings 4 million. The first to third respondents shall be entitled to 70% thereof, and the fourth respondent to 30% thereof. I have prepared a report of the court on electoral malpractices under Section 87 of the Elections Act, which is as follows. The court finds that the following malpractices of a criminal nature may have been committed. And directs that the same be transmitted to the DPP. A. Admitted alteration of register without authority, contrary to Section 6(1) of the Election Offences Act. B. Double assistance of voters, that is allowing 6 persons to assist more than one voter, each contrary to Regulation 72(5)(c) of the regulations. C. Failure to record in the polling station register against the name of the voter the fact that the voter was assisted, contrary to Regulation 72(6). I will make recommendations separately. I will not, because there's no point of putting the recommendations in the judgment, but I'll make recommendations separately, particularly for IEBC's notice, subsequent to this judgment, because I think it is important. Certificate of court as to validity of the election under Section 86 of the Elections Act. Having concluded the hearing of the election petition, I certify that the petition was dismissed and the fourth respondent remains the duly elected member of parliament for Mbeere North constituency. This information is to be transmitted to the Speaker of the National Assembly. Orders accordingly.
Yeah, my Lord, we are most obliged by the decision of the court. We have sat and listened to it. We appreciate where the court is coming from, but we, however, would wish to make an appeal in regard to some of the issues the court has dealt with. And therefore, my Lord, we are making an application for expeditious provision of typed proceedings, the judgment of the court, and the decree going therefrom. Your Lordship, the reason for the appeal is, my Lord, that this might be the only time the certain issues will be clarified by the Court of Appeal, most importantly the question of the alteration of the voters register. And my Lord, since I am not making an appeal before you, we would wish to make the Court of Appeal pronounce itself. Number two, Your Lordship, on the question of the scrutiny that was dealt with by the Deputy Registrar. My Lord, we have listened to you and the judgment, and we note that the judgment itself does not caption the entire report as reported by the Deputy Registrar, and most importantly in respect to ballot box number 35 and the 212 votes that were cast in foil paper. We have not heard you pronounce yourself on that, Your Lordship. Would therefore wish to make an appeal. And then, my Lord, I don't know how that will square out, because it has not been captioned in your judgment. Because, my Lord, when you ordered,
it should be easy enough, because the proceedings of the registrar will be part of the proceedings of the
yes,
court.
My Lord.
So you just annex them and say that the lower court failed to deal with an issue.
My Lord, we will be obliged.
Yeah.
We are otherwise happy that the court has made its decision. We'll try our luck in the Court of Appeal. We are most obliged.
Fortunately, the judgment is typed already.
Yes, my lord.
The proceedings are typed, so it should be fairly easy to get the record fairly quickly.
We will get it, my lord.
Okay. Yes, Waduta.
My lord, Waduta, and I thank you for that judgment. My lord, I just have one request, and as we review the judgment, so that then we can see what we make of it in terms of what is the next step. We would just like to make an application for stay of execution on the issue of costs, because we know we have money in court.
Go ahead.
Yeah. So that, my lord, the issue of costs may be given about 30 days for us to review the judgment before the money is released, if such an order is sought. So that then we can make the appropriate application, if any, upon taking instructions.
Okay.
So that, my lord, if, as Mr. Ndegojiro mentioned, if there is any need for review or clarification from the court, then we can have that period to consider all those options.
All right.
That's all right.
Thank you.
Yeah, I've been informed that I seek 45 days.
45 days.
45 days, all right.
I think you have 30 days, actually. I think, well, yeah, he's asking for 45.
Yes, I hear you, my lord.
Yes.
We would be opposing the request for stay, my lord. There is no indication upon which such a stay would be predicated, my lord. No appeal has been filed as yet.
Yeah.
Even the costs have not even been ascertained. My lord, on the second issue, the IBC takes note of the issues you have raised, and they welcome the report which you will be extracting and sending them from this judgment, my lord, which is going to inform the improvement in terms of how they conduct their affairs and how the elections can be improved better. Otherwise, my lord, on behalf of the electoral body...
Let me summarize it.
Yes, my
like
lord.
This.
Yes.
Just sit down. During the hearing of the case, almost without exception, every IBC officer who gave testimony asked, did you report? They also said, was this outside the polling station? Did this occur outside the polling station? I gave a long introductory discussion about the powers of IEBC because it is important for IEBC to remember that during or in connection with anything to do with elections, IEBC is the policeman of Kenya. It's not the Kenya police. So that you cannot wring your hands and say it was not reported, we don't have an OB. No complaint was made. You have seminal powers, IEBC. You have powers as a commission, even to investigate. You just need to read the newspaper. You hear something occurred, you run. Just like the Kenya Revenue Authority, when they hear ching, ching, ching in your mobile phone, they come running. That is how ABC is supposed to operate under this constitution and the laws. So that is one of the big areas I'll be discussing in the recommendations. In India, it is clear that IEBC behaved, sorry, not IEBC, the Electoral Commission there behaved the way IEBC behaves today. They changed. They became proactive. The code of conduct is enforced in India. And in fact, in India, the petitions are very, very few. I was there myself, personally. There are hardly any petitions because IEBC does its work. Yeah.
My Lord, while you're still on that...
No, this is not part of the judgment.
That's correct, that's correct, my
we are
Lord.
having a
It's also my
post,
observation. And my Lord, the reason why we would wish to have some of these issues clarified, would not wish, my Lord, even to disturb that kind of fighting, because, my Lord, this is the first time I have had an election court making such kind of pronouncements in respect on how the IBC is supposed to conduct. So, my Lord, even when you hear us making an appeal, we just want to make sure that we buttress some of those issues that you have said in your judgment.
But you will notice that in discussing the powers of IEBC and its authority, this was not in respect of an issue for determination. So all that is mostly, what? We call it what? Obiter?
No, it's not obiter.
What is
You're
it?
supposed to pronounce yourself in a manner that the law also speaks. It's not obiter.
All right. Anyway, you will take the judgment to the next court. But what worries me is what I see every day happening, because we are all Kenyans. We see things that occur. We hear when there's an election petition or an election, in any part of the country. It's reported in the newspapers. There are clips from all sorts of places. We don't believe everything, but we are able to get the general mood of people. And that mood, although we cannot represent it in our judgments, it has to come through evidence. Parties have to bring the evidence. Even all this bribery, I've actually seen myself clips of people standing in a line being given money. It's just that nobody takes them to court. But these are things that IEBC has the power to curtail, even under the Constitution. Under the Constitution. And the DPP cannot say that he's the only one who can investigate or prosecute, because the powers have been given under the Constitution through a statute for prosecutorial. So one of the things I'll be proposing is the setting up of an inspectorate of IEBC. That's one of the things I want to recommend. I can't recommend those things here because it wouldn't make sense. But there must be some kind of inspectorate. I don't know how Kenya Revenue or Kenya Anti-Corruption Commission, how they do it. But however they do it, they seem to be fairly effective. That's what we want with IEBC, because the Constitution guarantees us a free and fair election. It guarantees Weveti that when she is going to her polling station, nobody is going to sumbua her. No masumbuko. I'm going to vote, and I'm going to vote for who I like. And if I take your money, I'll still vote for who I like. Okay? So that's the key point. Sorry, anything else?
Yeah, Malone, maybe just obiter. Yeah. As I thank you for the way you have conducted the proceedings and the efficiency. Also to bear in mind the timelines which the respondents are really given to respond to this such a bulky election petition. A single 7 days.
Yeah.
Some of the irregularities, my Lord, which may go unexplained, could be because of this scarcity of time, my Lord. Otherwise, it's to say that yes, my Lord.
Do you put it in the report?
I did.
You did?
I did, my Lord.
Okay.
Otherwise, we take a lot of lessons as IBC, and we appreciate you a lot and your entire staff. Thank you very much, and even to counsel who appeared in this matter.
Okay.
Yes, my Lord, for the fourth respondent, we appreciate the announcement, except on one issue. I think Mandela has taken the bulk of the cost. Perhaps we'll have a discussion outside the court. We can share something with us. Otherwise, my Lord, we are happy in the manner in which you have conducted these petitions. We are also happy with the judgment that you have pronounced today.
Of course you would be.
Yes, naturally. Yeah. But on my part, I'm most impressed by the time you've taken to give IBC the teeth that it seems to have lost.
Yeah.
I think for me that's a very proactive judgment which will clean up the electoral practice in this country.
Yeah.
Otherwise, thank you very much from the fourth respondent, and we do congratulate you. And my colleague has something to say. Thank you.
My Lord, we welcome the well-reasoned judgment of this Honorable Court, which has really shed light on very pertinent issues that arose from the petition. And our client, for the respondent who is present, takes this opportunity to extend a hand of friendship to the petitioner. Now that the court has decided, and as we are aware, politics and democracy in their very nature are competitive, but it takes a wise soul to accept the electoral and judicial outcome in stride, and I recognize that Mr. Jiro is already in agreement with the position taken by this court, and indeed he says he wishes to go to the Court of Appeal to buttress the decision of this honorable court. So we are of the view that Mr. Jiro may want to take into consideration the will of the people, the constituents of Beere North, who would desire that going forward, the game moves from the court to the ground in terms of development programs, in terms of rendering of services, such that no more attention will be devoted to court proceedings. Therefore, the respondent has had a lot of distraction during the time when these proceedings were in progress. He had to shuttle between the constituency and the court, and that has unduly impacted on his ability to fulfill the promises that he made to his constituents. So we would be glad if this matter can rest at this stage. We continue to celebrate the wisdom of this court together with the petitioner, and it will be good for all of us, because sometimes you win, sometimes you lose, and even then the next election cycle is just 1 year away, and I'm sure our client, for the respondent, will be willing to make some considerations which would be favorable to the petitioner, depending on how the petitioner takes the outcome of these proceedings. Now, with regard to the prayer for the cost, we'll also be making an application that the amount deposited as security for deposit be released to the respondents.
Are you making that application now? Because I've already given a stay of 30 days, so even if you make the application,
Yes.
it will not affect the stay.
Very well, then the amount can be released to the respondents on the 31st day.
Judge, we thank you for the detailed judgment and the way the court has conducted this particular petition. I as a Karaoke Njiri, I'm the senior most for the petitioner, and on behalf of the petitioner, we thank the court for the judgment. At the same time, to remind my colleague, Mr. Kamodo, that the petitioner and the 4 respondents are friends, and they will remain as friends besides their political diversity. One issue, we would like the court to give directions on the electoral materials. My colleague had requested me to mention that, and also the keys that we are holding for the safe room going forward. We shall be inviting Judge Karodoi to thank the court formally on behalf of our team.
I forgot to say anything about the electoral materials. Obviously, they will be returned, but let that come through a direction that I'll give the DR, which will, so I'm just saying directions on electoral materials will be given to DR to effect. Yes. Thank you for reminding me.
Thank you, my Lord. I noticed today the role of the bar saying thank you to the court has been taken up by several people. I think it's what they say that success tends to have many fathers. But on behalf of the bar, we would like to say thank you for the way the matter has been conducted. On the end of the petitioner, we may not be happy, but we are grateful. We have been handled, managed, treated with utmost professionalism. And I think that no one sitting on this side can take it away from this court. And even next time, if there is, we will be more than happy to end up in this court. And we also hope that all the issues that we picked up for recommendation, that they are going to be acted upon to make the resolution of electoral disputes to be enhanced. And that is why I wonder, looking at the spirit with which we have gone, I was of the thinking that Mr. Kamotho or Dr. Adrian Kamotho should be looking forward to a robust appeal process which will actually even make these issues clearer instead of offering an olive branch while the petitioner is actually going after the whole tree and its fruits. So we hope that we will be fully facilitated with everything that we have asked for. And we wish the court all the best going forward. And thank you very much.
Thank you very much, Council. I take that with a lot of appreciation. If you noticed, I started by appreciating and acknowledging you all, because I didn't know what might happen after I make the final determination. And I didn't know whether there is enough security. No, thank you very much, Council. I have also enjoyed myself during this whole exercise. And you say when we do it again. I hope we don't. By then, I think I should be an elder doing an alternative justice system next year. But thank you very much, all. I appreciate you. Have a good afternoon. Oh, I have not used my gavel, and somebody complained. So let me use it today. Let me use my gavel because it has not been seen to be used. The proceedings are closed. May we stand?